So how many of you have ever heard of the term tort, but as it comes as a legal term? You've heard of it? No? Oh, I was like, pretty good, because most people haven't heard of it, is why I asked. Have you ever heard of the term tort as it relates to desserts? No, tort. Different than tortas, which are like Mexican sandwiches. I don't know whether to call it a sandwich or a panini or a torta. I've never had one. Do you know that? Because so if I go to a place, like if I go to like Pima, I don't know. If I go to the taco shop in Pima, right? They have good carne asada. So I'm always like, I don't want to order something else and be disappointed. I know I like their carne asada. So like they have tortas, and I'm like, I don't know. Try it. Is there a certain kind that's the most amazing? So asada, like okay, all right. So what I need to do is find somebody who is a connoisseur of such things and then be like, come with me and tell me. Well, I'll do that. No, if I go to a restaurant, like a foreign restaurant, and I don't know, then I'll ask the person working there, like, what's your favorite thing here? Like, I want to try it, right? All right. Anyway, but that's not what torts are. Torts are, oh, what is a tort? See, first question. All right. So a tort is a civil wrong. So a harm against another individual. Okay. And it comes from the Latin word tortus, which is maybe, I don't know, maybe tortuga comes from that too. Are they crooked? I don't know. Dubious or twisted. Okay. And so it's a civil wrong that interferes with someone's person or property in such a way that injury results. A couple of important definitions from a legal standpoint. Injury doesn't have to mean physical harm. You could be financially injured. That's another way. You could be emotionally injured. Okay. And in the modern world, that's challenging, right? Because everybody's emotionally injured by everything, but you have to actually show damage. Okay. We know that there's certain things that legitimately harm and hurt people emotionally or mentally, as opposed to other things which just hurt their feelings but they're still fine. But that's hard to define from a legal sense, right? So a tort is a civil wrong, not a crime, but a civil wrong. So we mentioned this before we even learned about crime, that a tort, so we have private wrongs and public wrongs. You don't get prosecuted. The government doesn't come after you for a tort. An individual does and says, you've harmed me in this way, and I want you to have to remedy that situation. Okay. All right. So torts are broken into 3 groups. I know it is. It sounds so serious, and yet the word sounds silly, right? Like, all right. So a tort is broken. There's 3 groups. Intentional torts. What's intentional mean? On purpose, right? It means you harmed somebody on purpose with intent to harm them. Okay. As opposed to a negligence tort. And negligence means, yeah, you were just dumb. Yeah. So when someone's negligent, it means they weren't properly careful. Maybe it would be a good way of putting it. Yeah, that's it. They were negligent, right? They weren't properly careful. Okay. So an accidental harm that results from the failure to think through the consequences. So if you think about it, like drunk driving is probably more of a crime of negligence than it is a crime of intending to hurt somebody. You're just like, oh, I feel fine, I'm just going to drive home. But you're not fine, and you probably knew you weren't. Like, by the time with drunkenness, you get to the point where you don't even know what you are, then you're usually not even trying to drive, you're just falling down, right? Anyway, and then there's a third type, which is more of a legal term, which is strict tort liability, and we'll talk about the difference. So just know that torts are broken into 3 categories. So let's start with the intentional torts. She thinks she just can't keep a straight face. All right, so the first most common that you'll see is what's called defamation, not defecation. That's different. That's pooping. Okay. Defamation is lying about somebody else, and it has to be published to a third party. So have you ever heard of libel or slander? Those are part of defamation. The difference is that slander is usually verbal and libel is usually printed. And so publication doesn't mean it has to be like written out. It means just put out there to people. Made public is what they mean by published. So, well, it tells you right there, slander and libel. So again, it's not against the law for me to tell a lie about you. It's just a crappy thing to do, right? But it's possible I could tell a lie about you in such a way that it harms you. It hurts your interests. Maybe it hurts your ability to get a job, or it gets you fired, or it hurts your marriage, or something like that. That would definitely be defamation. So here's an element, and the element means this is what it takes for this to be defamation. So it has to be about a business or a person's reputation or honesty, and it has to be untrue. So the first major defense to a libel claim is it's the truth. So if I go around telling everybody so-and-so cheated on their spouse, and then they try to sue me, and I go, I have proof, and you can prove it, that you didn't, you did not commit the tort of defamation if what you're telling is the truth, okay? Now, it may not be moral to tell the whole world about somebody's shady business. It might be, it might not be, I don't know. Sometimes cheaters deserve for the world to know, right? But it's not an issue of morality, it's an issue of legal standing to sue somebody, okay? So it has to be directed at a business or person, made with malice and intent to injure. Ooh, that's harder to prove. Or was I just gossiping, or was I trying to harm somebody? Someone heard it and understood the statement, and it created economic losses such as damage to reputation, or sometimes other losses such as like harm to a marriage or something like that. So if the person who's claiming they were defamed is a public person, in other words, a politician, an actor, anybody who has sort of gained or benefited by being in the public eye, then there's a stronger standard. In other words, it'd be one thing if I said something bad about Bethany, because she's not a public person, she chooses to keep her life private, and if I tell lies about her and it harms her, that's enough for her to sue me for defamation. But if she was a famous movie star and I started, saying bad things about her, she would have to prove I actually had malice, which means I knew the things I was saying were false. And with reckless regard as to whether or not it was true or false. Okay, so this happens a lot with organizations like TMZ. People will sue them for defamation, right? And again, because the people they're writing about are, the Prince of England and his movie star wife or whatever, there's this higher standard. So if they put something like, they were seen going around town with these people, first of all, that's probably true. But they imply, right, that there's something untoward going on, that they were cheating on each other or something. So that's why they can get away with writing so much of this stuff, is because you would have to prove they knew it wasn't true, and that it was done with malice, because they're public people, because they're people who have already profited by putting themselves out there anyway. Okay. All right. Biggest defense, it's the truth. It's the complete defense. So it's not defamation if what you're saying is the truth. Easy. So don't lie about people and you're safe. Okay. And then there's some other types of privilege or defenses, which is privileged speech. So absolute privilege is where I testify in court or in a public legal hearing like before Congress. What I say there is protected by privilege. So even if I lie about you in that setting, you can't sue me for defamation. Okay. Instead, you could come up and set the record straight with your testimony. Okay. So that's absolute privilege. Opinion privilege means I'm allowed to share what I want about you as long as it's opinion. So again, if I say Pablo is a horrible person, that's a statement of opinion, right? That doesn't harm, it might harm him, but it's especially if I was somebody whose opinion people cared about. But I would have to make some specific claim, not a statement of opinion. Does that make sense? Sometimes, usually it's pretty clear, oh, that was a statement of opinion, or that was a factual statement that was false. But there is this little weird gray area, right? Like, what if you say somebody is unfaithful? Well, what does that mean? You know, that one's like, if I said they were unfaithful to their spouse, I think everybody would know what I meant by that. But if I just say they're unfaithful, people would think I meant unfaithful to their spouse. But if questioned, I could be like, yeah, one time he promised me something and he didn't keep his promise. He's unfaithful. And so it was a statement of an interrelationship I had with him. And so it gets dicey if you're trying to collect damages for stuff like that. Okay. So that's the opinion privilege. So, okay. The second type of intentional tort is what's called contract interference. And this would be when you know two people have a contract and you intend to interfere or cause a breach of the contract. When you come in deliberately and try to break up somebody else's contract, okay? So that's what contract interference is. And then the original part of the contract is injured by the breach of contract induced by the third party. So in essence, if Sienna and I have a contract, we've agreed to, I don't know, she produces goods and I sell them. And so we have an agreement for her to produce so many for me and I'll sell them. If I just break that contract on my own, she could sue me for breach of contract, right? I broke the agreement we had. But if, if Bethany comes in and she starts saying, I know you have this contract, but I can do this and this, I can get a better supplier. And she induces me to break that contract. Now, Sienna could sue both me for breach of contract and Bethany for contract interference. Okay. But again, she'd have to prove that had it not been for Bethany's interference, I would not have broken the contract. And that's tough to prove. She could definitely sue me, but if she wants to collect more damages, she's going to have to make a stronger proof. False imprisonment. That is what it sounds like, right? Custody of someone else for any period of time against their will. Any period of time. So it's not like I only held them for 5 minutes. So this happens in weird cases where we wouldn't think of it. In business, it happens like, let's say Pablo's my boss and he calls me into the office to, talk about my behavior at work. And I'm like, I don't have to take this from you, Pablo. I'm out of here. And Pablo says, oh, no, you're not. And he slams the door and stands in front of it and refuses to let me go. That's false imprisonment. Now he could argue, like, Mike's a big guy and he could pick me up and move me out of the way if he wanted to. But would the scenario change if it was a tiny little woman and Pablo the athlete blocking the door? It might to a jury's eyes, right? Remember, we have a jury-based system here. And so that all gets played into it. Even if it's the same, tort either way, sometimes it's one thing if they're like, dude, if you didn't want to leave, because he could be like, I wasn't really imprisoning them. If they had just said, hey, the way I'm leaving, I would have. But a lot of it has to go now with if I sue him, my perception versus his perception versus was there a witness and what was their perception versus a camera and how if there was a camera showing all this, how would the jury perceive this? Because in order for it to be false imprisonment, the other person truly has to not be free to leave. And not be free to leave because of fear of like bodily harm or something like that. And so again, the thresholds to prove these things can be challenging at times. So that's where it comes up in business. It also often comes up in retail stores when they catch somebody shoplifting and they're trying to detain them until the police get there, right? Because people will sue them for false imprisonment. But their defense is it's not false imprisonment, it's legitimate imprisonment. I'm allowed to, it's called shopkeeper's privilege. I'm allowed to hold you until the authorities get there, right? Probably if we remember back, I told you about Savannah Redding versus Safford Middle School, right? Her case, she might have an argument for that. But it's hard, right? Because a school has the parents' permission to keep the kids at school. In other words, if a kid leaves school, parents are going to be like, whoa, what was my kid doing out on the street when he got hurt? He was supposed to be in your custody. So they do have the authority to detain you, but only until, like, you know, they call your parents or whatever. So these things, they'd come up a lot in business in those areas, mostly like with retail, stuff like that. So in here, you don't have to establish physical damage. Just the fact that you're detained is damage. If you think about it, if somebody was actually holding you against your will, even if they didn't physically harm you or you didn't lose money, maybe, you know, because you couldn't go to work or something, just being detained against your will is damaging. That's the idea behind that. The main defense, like I said, shopkeeper's privilege. I can detain someone for a reasonable time if I have a basis for that. And there's probably, you know, even like, let's see, you know, I see Auden, he's getting attacked by someone out here, you know, like that preacher guy just attacks him. And and he's just beating up Auden. And I jump over there and I kind of intervene. And then I call the cops, and the preacher guy's trying to flee, and I grab him and hold him, and maybe 10 of us jump on him and hold him till the cops get there. He'd have a hard time arguing false imprisonment in that case. We were acting reasonably. We detained him the reasonable time until the cops got there. And we had a reason. We saw him physically assaulting somebody. Does that make sense? So it's not just for shopkeepers. We could detain somebody if there's some reason for it. But remember, you're then putting yourself at risk, because a jury is going to decide, was that a reasonable time? And was there a basis that was reasonable? And when they do this, they use something they call, I know it's sexist, okay, but they call it the prudent man principle. Sometimes some states have changed it to the prudent person principle now, which means, would a normal, prudent individual viewing this situation agree that that was reasonable? What's really hard about that is we know that the definition of what's normal and reasonable is fairly close. Like if we all were like to survey, we'd be pretty close, but there'd be some differences in our opinions. Intentional infliction of emotional distress. So it can, again, so here's the legal standard: liability for conduct that, quote, exceeds all bounds of decency. Again, that's vague. So if I tease you and it hurts your feelings, probably not intentional infliction of emotional distress. But let's say I tease you, it hurts your feelings, you let me know it hurts your feelings, and then I just say, you're just being a wimp, and I tease you more, and I continue every day, but you feel like you have to come to class or you're not going to pass and you need the class to get your degree. At some point, does my behavior begin to exceed all bounds of decency? Like if I know I'm hurting you and I continue to hurt you, probably, right? And again, a jury has to decide that with some definitions a judge is going to give them. So it's difficult for plaintiffs to establish emotional distress. And in business, one of the big areas has been the use of debt collection, right? Is it okay for if you owe someone money, Allie, if you owe someone money, if you talk and I ask you a question, then it doesn't break your, but if you owe someone money and they call you and say, hey, I need you to pay that money, do you think that exceeds all bounds of decency, or is that normal? Right. What if they call you once a day for a month, for 2 months, for 3 months? Have you paid it yet? I need you to pay me. Have you paid it yet? I need you to pay me. It starts to get weird. What if they call your employer, your parents, and say, Allie hasn't paid me? You see what I'm getting at? Like it could start to hit some point where it becomes excessive. And of course, like, you think of like a mob scenario where they send someone to collect the debt, right? Who, they don't hurt you bad, but they just rough you up a little the first time. And then they break your knee the second time. And you're like, you can't break a knee, dummy. It's a joint. It's already broken. All right. All right. Crack your patella. All right. Invasion of privacy. So this is intrusion into the private affairs of another. In other words, paparazzi, they do this a lot. The TMZ again, right? The only reason paparazzi exists is because there are outlets who will purchase their work, right? And who want to buy these pictures of stars and famous people in their private, settings. So if you're walking down the street and I take a picture of you, sell it to a magazine, do you think that's an invasion of your privacy? You wouldn't like it, but you were in a public place. That one's tough. Okay. What if you are in your backyard at your own pool in the backyard of your house, reclining in the sun? Is it okay to me to climb up on some high thing somewhere with a telephoto lens? No, that starts to be really bad, right? And so that's an invasion of privacy. Where that line falls is super challenging in the modern era. And what I mean by that is, how many of you have taken a picture of someone who didn't know they were getting their picture taken and Snapchatted it to a friend? Admit it. Everybody does it. It's usually someone doing something derpy or something, right? And you're like, check out this guy at Walmart, send it to your friend or whatever, right? Like, is that an invasion of privacy? I don't know. It's in a public place. It might be embarrassing to the individual, which means it's probably not nice. In theory, we should never do things that would harm or hurt other people's feelings even. But we've probably done it. I know my kids take pictures of me and I'm like, dude, like, let me know. I don't like the idea that there's a picture of me floating around out there that I was not even aware was taken. It's weird, right? Anyway, you're like, it's Snapchat, it disappears. No, because people just screenshot, right? Not that hard. All right. And similar to this would be like public disclosure of private facts. So there's facts about your life that are private to you. And so this is one of the ways they get around the defamation lawsuits, where they're like, well, it was true. Yeah, but some stuff is true. And you can tell everybody, like, so-and-so cheated on their spouse. But some stuff, like your medical history or your educational history or stuff like that, is private by its nature, and appropriately so, right? So for me to, like, let's say I find somebody's medical records that shows they had an abortion back in 1997, and I just publish that out there. Most people would agree that that is an invasion of their privacy that goes beyond bounds of decency. I think even pictures of people is beyond bounds, but something like that would definitely be a horrible thing to do and could harm them, right? And it could harm them in the sense that they're going to get picked on by people. They're going to get, it just depends on what their situation is. For some people, it'll be like, yeah, no big deal. I had an abortion in the 1990s. But, think of someone who, like, say now is like a prominent Christian pastor in town, but had, started off kind of rough and had got pregnant when they're in high school. To tell everybody about that is not anybody's business, because hopefully none of us are just what we were in the past, right? And some people will be like, yep, I did. And now look how I've grown. And other people would be like, it would be devastating to them for that secret to come out. All right. Because of privacy being such a huge issue, there are statutory protections. HIPAA, H-I-P-A-A, protects healthcare privacy, like I was mentioning. So, like, the hospital wouldn't be able to release even like my wife's medical records to me, right? They can only release them to her. And the same, this is getting dicey right now when we talk about the rights of children, right? Because there's some organizations that are like, parents shouldn't have a right to their teenage kids' stuff. But the law hasn't caught up with that. I don't know if it even will, because there's such a debate about it. Like, if so, what's the age? As a parent, do I have a right to see my child's healthcare information when they're 17, 16, 15, right? Can my 17-year-old daughter go get an abortion without my knowledge? All those sorts of things. And now, like, gender affirming care, right? Can my 17-year-old son go seek gender reassignment surgery without my knowledge or consent? So this is still an evolving area ethically as well as legally. Okay, almost done with the intentionals. I know there's a lot of them. Appropriation. That means using someone else's name for commercial advantage. So it can either be used without permission or used beyond permission. So if I'm like, Bethany loves eating my ice cream that I make at my ice cream factory, and I used, her picture and her name, because she's a famous movie star or something. Next year she's gonna be a famous movie star. If I do that without her permission, or if she gave me permission to use her picture, but then I start putting quotes that she said that she didn't say, okay, that's beyond her permission. That's appropriation. Usually what they'll do is sue for what's called enjoinment, which means you have to stop doing that, and then for any damages, like either it harmed me or for this is how much you should have paid me to use my name, something like that. All right, so those are the intentional torts, meaning on purpose. You chose to harm somebody through deliberate action. The second is called negligence, which means not on purpose, in essence, right? It's accidental, but not a true accident in the sense that like it was an unforeseeable thing. It's accidental on the basis of not taking due care to avoid harming someone else. So in order to establish negligence in a legal sense, is anybody else a member of the Hellfire Club? Just one? You are? Oh no, I thought you were raising your hand. It's a Stranger Things thing. All right, yeah. That's a Stranger thing you have on there like that. All right. Element 1 of negligence. You have to establish, if I want to establish that Christian was negligent, I first have to establish he has some duty toward me. Okay, so that's the first element. So all persons are expected to behave as ordinary, reasonable, prudent persons do. So for a public sort of situation, the basic duty that we all have is to act as ordinary and reasonably prudent people are, which means, again, that seems mushy sometimes, but it means things like if we're driving, we stay in our lane, right? We're driving on the right side of the road. We stop at stop signs. We don't speed, which we know normally reasonably prudent people all speed. But that's what I would argue sometimes, would be like, well, what Discovery Park Road, 35, really? No way. Anyway. So here's an example. They go, the standard of the law is not always used. If there was a speed limit of 45, but the road was icy and snowy, they could argue that even though you were going the speed limit, you were not driving as a prudent person would. Most prudent people would slow down and be more careful in that setting. Okay. I don't know if you could argue the opposite side of it though, like everybody speeds there. I would think you should be able to, but I don't know. I think the law might provide the upper limit, but not the lower limit. Element 2. So I have to establish that Christian had a duty and now he breached that duty, meaning he didn't keep his duty. Okay. So failure to comply with established standard of conduct. That's the second element. We'll skip back to this. Third element, causation. The fact that he had a duty and he breached his duty is not enough to say he was negligent. I have to say his duty and breach thereof led to, caused injury to me. Does that make sense? They use, it sounds funny too. As funny as tort, the but-for test. You're like, but for? What? That's just weird. But it means I would not have been harmed but for his actions. That's what the but-for test is, okay? So the idea is, like, I'm driving down the road and the wind blows me into a snowbank and I wreck. And then Christian passes by me at a faster rate of speed than I think is prudent. I would have to try to argue that it was his vehicle that caused the wind that pushed me. It would be an uphill battle to prove that. Whereas if Christian were passing by me and he swerved or something to avoid a cat in the road, and that cat and I had to swerve to avoid getting hit by him, and then I crashed in, I could say, if it hadn't been for his swerving into my lane, I wouldn't have wrecked, and I'd have a better argument. Does that make sense? Especially if I had witnesses saying, oh, I saw this guy swerve. He was saving that adorable little cat. You can't blame him for that, the kitty, right? All right. And then the fourth element is what's called proximate cause, which is foreseeability. In other words, sometimes there could be multiple causes that lead to something happening, right? Like my car, my tire comes off of my car. You ever been watching like those Indy 500 races and a tire like goes flying into the stands and like kills a person, right? You're like, what the? So you'd be like, okay, what caused it? Well, the driver was driving at a high rate of speed on a turn and hit an imperfection in the road, and that caused this accident, whatever, right? So then you'd have to be like, well, what was the proximate cause? Was it that he was driving at a high rate of speed? Yes, but it's the nature of these things. Like it's an Indy 500 race. They drive 200 miles an hour plus. Was it a faulty, something on the vehicle? Was it a faulty something on the road? And so what they would have to do when they're figuring out who to sue for this tort of negligence is figure out what of all these different causes, what was the proximate cause? What was the foreseeable thing that somebody should have protected against? And that's sometimes hard to do because there's a lot of variables in accidents and things that harm people. Okay, so proximate cause means foreseeability. All right, so that's the four elements you have to prove if you want to sue somebody for negligence. They had a duty, they breached their duty, that breach of duty led to harm, and which is causation, and that it was the proximate cause, not just a cause, but the cause that was foreseeable. Maybe another way of putting that is there are causes to accidents that we can control and that are foreseeable, and ones that aren't. And so, like, I can't control a pothole in the road, but that was probably foreseeable that the county knew if they didn't fix the road, it could harm somebody. So the proximate cause would fall on the county, not on me, even though I hit the pothole and then wrecked into somebody. You see, so a lot of times what will happen is they'll sue me, I'll sue the county, and then anyway, so just that proximate cause is one that gets confusing. So those are the four. Imagine that there's four steps or four things. You could imagine that popping up on a describe the four elements of negligence, right? Like on an exam or something. All right. And then the fifth element is that it actually harmed you, that there's damages of some sort. That can include medical bills if you're injured, lost wages if you're injured and can't work for a while, pain and suffering, which is the one that's like people try to fudge it, right? Like sometimes they legitimately suffer. And then loss of consortium, which means like if you lose your spouse because of someone else's negligence, you lose all of those benefits that being married provided, just the love and care and value, so to speak, that comes from that. So pain and suffering is hard though, right? I think I told you guys I had a son who was in a serious car accident while he was on his mission. And he was a passenger in a car that was being driven by someone else. And the person, they think maybe had a medical episode. They don't know. He died in the accident, so he didn't get to explain. But he was exiting the freeway and was saying, I can't get it to stop. I can't get to stop. And it was accelerating. And he was coming up. You know how when you're exiting the freeway, you come up on the light where everybody's waiting. So rather than hit the cars at the light, he turned into a concrete barrier on the driver's side, killed the driver, didn't harm the person in the passenger seat at all. He got a couple scratches. And then my son was in the back seat and he broke his back, broke his neck, broke his leg, lost one kidney, lost his spleen, broke ribs on both sides, had collapsed lungs and hematoma on both sides, had, what else did he have? It really jacked him up. Okay. Like, you like lost a kidney. What? Like, like when they said that, I was like, so like, oh, he has another kidney, he's fine. So he was in He was in ICU for 10 weeks. No, I take that back. He was in ICU for 3 weeks and he was hospitalized for 10 weeks. And then another year of physical therapy and stuff on top of that. So 2.5 months he was stuck in the hospital. What's the pain and suffering on that? What's the dollar amount of that pain and suffering? He lost weight. He's about my height. He got down to 135 pounds because he couldn't eat because it had messed up his insides so much. Now he's back up to 160, but even 160 at my height is skinny, right? Like, how do we say what's an appropriate amount of pain and suffering? Well, A, should I sue them? My son was an innocent victim of another person's negligence, right? My son has medical conditions that will probably plague him the rest of his life. Broken backs hurt forever. They never stop. I'm concerned that maybe when he's old, he may not be able to, work until normal retirement age because of the pain. So that's what suing is for, right? It's not to get back at that bad, horrible person. It's like, do you actually have financial damages? His hospital bills were $875,000. Luckily, my insurance paid most of it. And so, what do you do? Can you put a dollar amount on that? And is it appropriate to try to put a dollar amount on that? In our case, the guy's insurance company said, this is the limits of his coverage. We know, and said, we'll pay you this much if you want. They just offered to settle for the limits of his coverage, and said, if you want to sue, then you'd have to try to get it out of them. And the guy that was driving didn't have, he wasn't like a rich guy or something. And so we settled with the insurance company. And with the insurance company, what they do is, in essence, you just have to sign a paper that says, I will not sue this person, right? Like, I agree that this settles any disagreement between us. And so we were never going to sue. This is a nice old guy that was giving the missionaries a ride somewhere. We were never going to sue. We probably wouldn't even have realized that we could have got anything, except the insurance company contacted us and said, we know you've got huge medical bills. We know he's going to have problems the rest of his life because of this injury. We can offer you this amount of money, which is the limits of coverage. And so we did. We took that money and we invested it for him so that hopefully if he has to stop working when he's 45 because of like a medical retirement, he'll have some funds there available to live on. So just recognize that we tend to think sometimes as people who are suing, as people who are trying to manipulate the system or get money out of people, and that does happen. But often there are also legitimate reasons to try to get compensation, like because you've had medical bills, because you may not be able to work in the same way that you would have before. All right. Defenses to negligence. So if someone sues you and says, you were negligent, Sienna, the first defense is what's called contributory negligence, which means we were both negligent. In some states that allow contributory negligence, it's a complete bar to recovery. So I'll give you an example. We take a class trip and we all go out on a boat together. We're having fun. We're all drinking beers because we do that. We're just talking about the law, getting hammered on the boat. It's a good time, right? And Sienna doesn't partake, okay, but the rest of us, we're just getting wasted. But anyway, so I'm like, check this out, guys, and I like slam the accelerator on the boat, and it takes off, and Bethany tumbles. I mean, she's a little drunk, okay, but she tumbles and she hits her head, and she gets a concussion, and she's bleeding. So like, we have to stop what we're doing. The question is, did she fall because I hit the accelerator, or did she fall because she was drunk? And the answer is probably some of each, because Sienna, who hadn't been drinking, it didn't make her fall over. She was just like riding it, but she has incredible balance, okay? You didn't know by sitting in the front row, you were going to most often be my examples, right? So in states that allow contributory negligence, if I could prove it, if I could say, look, she was wasted, And so, yeah, I shouldn't have hit the gas, but she also shouldn't have been so drunk that she was falling down anyway. She could, that would be it. Complete bar to recovery, meaning you wouldn't be able to sue me. It would just be dismissed because of contributory negligence. Other states have a standard they call comparative negligence, where they try to compare what's going on and say, okay, and this is super hard to do because it's arbitrary, but say, okay, let's say like 50% of Bethany getting hurt was because of her drunkenness. And it's an embarrassing, sorry. And 50% of her getting hurt is because this idiot hit the accelerator. And why was their class out on a boat anyway? Because we like to party. All right. That's why. And so when they, in those states, what they would do is in essence say, they'd figure out an award, let's say your medical bills were $20,000 and you lost 10,000 from not being able to go to work, and then your pain and suffering. And so let's say they come up with, $80,000 as an award. In essence, they would say, I'm only liable for half of it because the other half was your fault. So that's how comparative negligence works. And then the third one is the assumption of risk, which means the plaintiff knew there was a risk and did it anyway. Here's the guy with cotton balls all over him smoking a cigarette. Okay. The question is like, should he have known, should he have recognized that there's some risk involved in doing that? Maybe a better example would be like if you go skydiving, right? They usually will have you sign a big waiver, right? And that waiver is a written proof of assumption of risk. Not only assumption of risk, but that the risks of this activity were detailed to you before you did it, and you still chose to do it. Then you wouldn't, it would be very hard for you to prove they were negligent unless it was like they totally didn't, take the normal safeguards. Like they forgot to give you a parachute before they shoved you out the door or something. Like, oh crap. Well, here goes another one like that. Like, so assumption of risk means you were aware of the risks and you still chose to do it. Because we do, right? We choose to do risky things. It's part of humanness. Are you a horse person? Do you ride horses? Yeah, it's risky, right? You can be harmed when you're in ways that just walking down the road you probably couldn't be by a horse. They could buck you off and you could hit your head, or while you're trying to saddle them up, they can get annoyed with you and kick at you or whatever. Maybe your horse would never do that, but you ever been kicked by a horse? Yeah. And you knew it was risky to be near a horse that was agitated. All right. So right now, and for the last 20 years, there's been talk of something called tort reform. If you Google it, which you probably will because you have an assignment that requires you to do so later, but the idea behind tort reform is some people feel like the system is set up that it's not really individuals getting helped, it's just lawyers, ambulance chasers, people call them, kind of going to people and being like, you should sue, because lawyers usually get a percentage of the recovery. So like if I can, if I can convince Auden to sue Pablo for $10 million, and we know Pablo's rich, so and he wins $10 million, and as a lawyer I get 35 or 40% of that, that's a pretty good living. I just have to win one of those cases a year, right, to have a pretty solid living. And so there's people saying there should be limits on verdicts, meaning like some cap on the amount that people could be asked to pay out. Like they want to limit it to like the actual damages plus some limited amount for pain and suffering, like no more than $100,000 or something like that. Because it's the huge verdicts that are pushing the lawyers, $10 million, I'm going for that. Whereas if it were limited to the actual damages plus some limited amount, people say there'd be less frivolous lawsuits. So these are attempts, and then standards for recovery, like almost like if you ever look at your insurance, your health insurance documents, it'll be like, we pay this much for an x-ray. And so doctors can't just charge anything and the insurance pays it. The doctors agree by doing business with the insurance, this is how much they'll charge. So there's some people who think there needs to be something like that, like, okay, if this is what happened to you, this is the most you could recover. Anyway, so just know that this is still an issue that people are trying to push for reforms to tort laws and how they work. The last type of tort, you're over it now? Okay, is what's called strict liability. So strict liability torts are this kind of special case where it's not necessarily on purpose and sometimes not even negligent, but because of the nature of the activity you're involved in, you may have liability anyway. Sometimes they put in a statute. So let's say like power plant, right? A power plant does some dangerous stuff. They burn fuel to generate steam, and then that steam turns a turbine and generates high voltage electricity. So in all of those processes, people could get hurt if something goes wrong, right? And it could be something that's totally an accident, like a turbine just fails and you can't find any reason for it other than, so statute might say, for this type of work where there's this much danger, the employer is going to be responsible if employees get hurt, even if they're not at fault. And so that's how strict liability works. There's statutes, or sometimes public policy, like for example, if you're a manufacturer and you make cars, if you make 10 million cars, even if you do your whole process as right as possibly could be made, you will probably still have some that are defective that come out in the end, just because of numbers, because you made 10 million of them. And so maybe only 10 out of the 10 million, a 1 in a million thing, kills somebody. The question is, should you still be liable, or should you be able to defend it on the basis of, I make 10 million things, I do it right? No, strict liability. It makes sense that the manufacturer would pay for a faulty product, even if they weren't negligent in any way. Does that make sense? So that's the idea behind strict liability. It's typically like either statutory, where the law says this is who's going to pay if somebody's injured here. Here's who will pay for, an environmental disaster, an oil tanker. Things could happen to an oil tanker that wouldn't even be the captain of the boat's fault. Something could happen. A storm comes, he does everything right, and it still makes him capsize and they spill oil. Whose job is it to pay for it? That's how strict liability works. It's theirs because they were engaged in moving crude oil, which is dangerous by its nature, and they knew. It's almost like an assumption of risk, isn't it? All right, so that's your tort law. Some people find it really fascinating. Other people find it miserable, and they just have to sort of grit their teeth and get through it. I'll leave it to you to decide which. Have a great day. I think on, what's today, Friday? On Monday, we'll get to take a look at that famous case where the lady was burned by the coffee at McDonald's. All right, pretty good stuff. It'll be interesting. Have a great day. Have a great weekend.